Good afternoon, or, you know, just a little bit more about what's saying about the judge's summing up and how it was effectively a direction to the jury, place to find Lucy Letby guilty, essentially. I believe it was. I'll try to explain why I think I believe it was, and I'll read out these. This happens to be from Judith Moritz of the BBC, who's apparently working on a book, so can make a few quid out of that as well. You know, it's a cash cow for some people involved. You know, they're making a lot of money out of this miscarriage of justice. I'll try and put the picture up at the end, or maybe during the video if I can figure out how to do that. I'm not very experienced with making videos, the technical things. Anyway, by the by, there's a tweet. This is about Goss's, the judge's Goss's 2 statements, directions to the jury. Goss, first one. The defendant denies she ever harmed any baby, including baby K, or has any such tendency. If she has satisfied you that she probably did not commit the offences of which she has been convicted, then you should ignore them. The second tweet, Judith Moritz again. Goss, reporting what Goss has said in the instructions. If, on the other hand, she has not satisfied you of this, then you have to decide whether these convictions show that the defendant has a tendency to behave in the way alleged in this case. There's so much wrong with that. I'm trying to tease it out. The burden he's placed on the jury there, despite saying that they mustn't consider any other research or any other viewpoints outside of what they hear as evidence in that trial about that allegation of attempted murder. Despite that, he's saying that he's placing a burden on them that in their own heads, as well as dealing with what they've heard about the attempted murder case in front of them. And they weren't jury members at the first trial, but he's saying that they could independently they could have the scope and the ability. How would they have this? How would they have that ability to state that they got this feeling that all those convictions were wrong? But on what basis could they, unless they're an individual who's researched it, and in the way of many people have, or a growing number of people have over these months, from what basis could they, as he says here, that they should ignore those previous offences that she's been convicted of, because they don't believe them, even though she was convicted of them, and they're in a court and they're being told by the judge, you know, we convicted this person that you're judging about this case of all these other crimes, 7 murders, 8 attempted murders, but I'm going to put it over to you that you can independently, if you want, you can disregard all that and simply not believe it, and not believe any of the convictions were right. That's putting them in such a false position, because on what basis would he expect them to overturn in their minds all those convictions? On what basis? What argument? He's saying that they mustn't have looked at any other arguments, and nothing's come up in the trial itself other than Lucy Letby's very simple denial. All the counter arguments that failed to come up in that first trial haven't been broached in this second trial to give the possibility and the scope and just simply the possibility of that jury in this baby K trial to overturn in their mind all those verdicts and say we should ignore them because we don't believe them, they were just, and she's innocent of all those. So so just to crystallise it, he's placing a burden on them that the only way, effectively, that they should give a not guilty verdict is in effect by saying she's not guilty of anything, all the other convictions. And I believe she's not guilty of anything, of course, but he's placing that burden on them to say that it's conditional, actually. He's making it an implicit condition that they in their minds have to decide that all the other convictions were all incorrect, and it's effectively a miscarriage of justice, in order to ignore them so that they may do the second thing, which is here. In order to ignore them, in order to bring a not guilty verdict. The defendant denies she ever harmed any baby. If she satisfied you that she probably did not commit the offences, but she's been found guilty of committing them in law. But he's asking them to consider. He's moving all those other cases into the courtroom and saying, knowing that she's been convicted of them in the same courtroom or in the same judicial system, and she's undergoing the punishment for it. He's saying that it's kind of quite subtle, this, and maybe it's not so subtle. It's very devious. It's incredibly devious. If she satisfied you that she probably did not commit the offences, so probably did not commit them. She's been found beyond a reasonable doubt to have been found. Not de facto, not that she did commit them, but she's been found in the court to have committed them beyond a reasonable doubt. And he's placing the burden on that jury in relation to this case, that they must, as a sort of hurdle, in order to because of what comes next. Because the next section of it is that if they can't do that, if they can't in their mind say, oh well, I can't say whether she was not guilty of all those other crimes. I'm not a jury member for that trial, and it's concluded, and she's been found guilty. If they can't do that, this is the kicker. This is what comes in. Then they must decide that she has a tendency to behave in the way alleged, and that's an implicit direction to say, well, this is a continuation. Baby K is a continuation of that tendency, and why would it not be then? Why would it not be? So Lucy Letby, he's putting Lucy Letby as well under this charge in relation to the jury's observation of her, that Lucy Letby had to, in that trial of Baby K, to fight again the first trial. How is she going to do that when she's not being allowed to bring all the other evidence that could have been brought? And that's not going to be shown in any case until we get to some kind of retrial or appeal. It might sound like I'm rambling. I hope I'm getting this across, that it seems like he's putting it on both sides. Oh, you could do this, you could do that. But it's not that. It's the coup de grace. This is a coup de grace. And it's saying effectively to the jury, and this is the sotto voce bit that you wouldn't hear, but you do hear it. They do hear it. The silent bit, the subtext is this. Well, I kind of know that you've heard that the police's evidence has been trashed, and Nurse Williams has contradicted the star prosecution witness Jairam, and his stories all over the place, and his memory's getting better over time. He's got all the timings are all out, and so on and so forth. The issue about the alarms, all sorts of things like that. The fact that his simple statement is his evidence says, I came in there, I saw her doing nothing. So what evidence is that of anything? Nothing. There's nothing. There's nothing there. He's that's the subtext. I know you've just sat through a ridiculously weak prosecution case that the defence have just ripped to pieces. It's fallen apart before your eyes. But never mind that. Worry ye not, because what you could do, What you could do is consider that she's been convicted of loads of other crimes, and this is kind of just a shoe-in, isn't it? This is just, we don't need to worry about what's happened. We don't need to worry about what you've heard in this case, in this trial, really, because what's going to trump all of that is the fact she's been convicted of all these other crimes. But the only way you will not allow that to trump this trial about Baby K in your mind, about the weakness of the prosecution of Baby K, related to Baby K in your mind, the only way you could not allow it to trump those convictions, is if you independently, not being a juror in that 23 trial, but independently decide that Lucy is innocent of all those other charges, even though you weren't at that trial and didn't see all the evidence. It's placing them in an impossible position to act fairly based on the evidence that they saw at this trial. It's putting them in an untenable position so that he's guiding them, and it sounds sort of plausible until you begin to dig into it. Because he's kind of saying, well, no, you could decide she's not guilty of anything. So it's either she's not guilty of anything, that's the burden he's placing on them. I don't think she's guilty of anything, but that's not the point here. The burden he's putting on them is that they've got to find her not guilty of anything in order to find her not guilty of this attempted murder charge. Even though the anything, all the rest of the other stuff, has already reached a conviction. What a kind of cheat is that? What a low, unscrupulous. I don't care whether they can make a legal argument for saying he's got the right to do it. That's an utterly unjust, unscrupulous, immoral. I can't think of all the words I want to use, but dishonourable, mendacious, really, because he's not really saying it's the inference, it's all there under the subtext about what he needs them to do. He knows it's going to happen. He knows it's going to happen. He knows the effect of that, and he knows allowing the prosecutor to keep referring to all the other murders, what the effect of that is. He should have stopped him and said, no, we're just dealing with the Baby K case. That's all out of the window. We're just dealing with this case here. It's a different jury. They weren't at that other trial. You can't place the burden of them having to independently now, after all this time, say off the top of their heads, oh no, she's not guilty of anything then. So that's how like I said to someone on Twitter, how he's weighted and tipped the balance of the scales hugely. So Lucy again was fighting against all the convictions there in that one trial about Baby K, not just about the evidence about Baby K. She was fighting all of the convictions that had just happened and all the monstering that had happened subsequently in the press and on social media and everywhere. And the idea that it's become a fait accompli, it's an accomplished fact that she's in law guilty of all those crimes, and yet he's saying in this fake, manipulative way that they could independently just say, oh, well, maybe she's not guilty of anything, and therefore then I won't allow that to affect me. But if I can't do that, I've got to go with the idea that it's a tendency. And that makes the decision very easy for me. Because it would take a very, very strong individual to pull all that apart while you're in it as a jury member. And just to say, as a jury member, that likely as not, very unlikely, has gone through all the alternative approaches and views of this matter and all the evidence that hasn't been looked at and all the arguments, medical and otherwise, scientific and medical and logical and otherwise, they haven't necessarily gone through any of that. All they've known is this person has been found guilty of 7 murders and 8 attempted murders, and just here's another one. And they think, well, all those other parents and the babies got justice. Well, why would we not give justice? It's a tsunami of pressure pushing them into that decision because they bring in all those other convictions. So that wasn't a real trial in any way whatsoever. It's a show trial. To put another nail in the coffin lid. It's a show trial. They knew the answer. The only way it couldn't have come out like that is if it had the majority of people, or maybe 6 or 7 people that had been looking at this trial or looking at the whole story and the whole case in great depth, not from the mainstream media point of view, but from all these other people that have been dissecting it in all sorts of ways, medical, scientific, statistical, in all kinds of ways. Yeah, I'll just finish on. There's another thing that a gentleman, I think it's a gentleman, is called on Twitter called Overlord Mainstream 1 at Overlord Mainstream 1. That's his handle on Twitter. Put a really good, very trenchant and powerful kind of infographic picture with a picture of Jairam. I'll see if I can put it up now on this video. If not, I'll add it to the end of the video. And it's a picture of Jairam, and he's got a speech bubble coming out of his mouth, and he's saying this. Last trial, that means 2023 trial, the last trial, I glanced at my watch, and it was 03:50. I waited 2.5 to 3 minutes, then went into room 1. The trouble is, that's where baby K was. Trouble is, Chester police screwed up the swipe data, meaning that nurse Joanne Williams was returning at 3:47, not leaving. This trial, this one that's just happened, this is him speaking, Jairam. I had to shift my timeline to 2.5 to 3 minutes after 3:41 a.m. and went in before Nurse Williams got back. He had to change his story because the police's evidence was wrong, so they just adjust the story. Doesn't matter. That's another thing about Goss the judge, by the way. You know, he didn't really. Did he hammer that home to the jury? How all those timings have been trashed, and how the story's been trashed. Jairam's story. Did he? What he's done is the opposite of that. And I'll just say it again once more, that he's just loaded the scales on one side, on the guilty side. Ridiculous. He put a couple of hundredweight of weight on it by saying, well, you can bring in all the other murder charges, and the only way that you can't is that you have to, explicitly in your mind say, well, she's not guilty of any of the other ones, and even though they weren't the jury for that trial. Put that expectation on them. Hideous. This trial, this Jairam speaking in this speech bubble, I had to shift my timeline to 2.5 to 3 minutes after 3:41 in the morning, and went in before Nurse Williams got back. But the trouble is, what Chester Police didn't tell me is that Nurse Oki got back at 03:40, screwing up my timeline yet again. And then he finishes here. Overlord Mainstream is put in this bubble as though Jairam's speaking. I hope that David Davis doesn't start poking his nose in, because David Davis was asking some questions about this case in Parliament and why, in relation to the concept of open justice, and why the New Yorker article had been banned from view, which hopefully it will be open to everyone to see soon. I'll get back to reading through it and discussing that soon. But I'll try and put those pictures up during the video, and if I can't, I'll just stick them at the end. The 2 Goss statements from his summing up, and the Jairam thing that Overlord Mainstream really very powerfully put together in this image. But that's it, yeah. I don't know, if it's just hideous. What Goss was the right person for the job. I think he was chosen for this job. I don't think they didn't take a chance on this. They didn't take a chance on who the judge would be, put it that way. They didn't take a chance. A safe pair of hands to deliver effectively what the state wanted, because this issue is so huge. Once the miscarriage of justice is overturned, and when that happens, the fallout is so huge for so many arms of the state and the NHS that they needed someone who would tip the balance. They needed a corrupt judge, essentially. They needed someone without honour. They needed someone without a sense of fairness. They needed someone who could seemingly subtly be impartial and say, oh, well, yeah, you can disregard it all, but you'd have to find her in your mind not guilty of anything in order to find her not guilty of this trial here. And that's the measure of this man, Goss, that he would do that. And for some people, I don't think they'll see it. They'll just say, oh, well, he gave them they could go either way with it. But that's not what that trial should have been about. It should have been about the strength or otherwise of that prosecution's case. And it was weak as piss, wasn't it? Or weaker, obviously. It was undermined completely or smashed by the defence. Smashed it to pieces. That they can deconstruct and smash it and undermine it in front of the jury. And yet, because of directions like Goss gave and how is it Johnson, the prosecutor, I'm forgetting some of the names, how he was allowed to carry on and just keep on hammering to the jury that doesn't really matter how weak and pathetic and useless and how many mistakes stroke lies are in the prosecution's evidence and the police's evidence. It doesn't matter really. Timings don't matter. What Nurse Williams says doesn't matter. In fact, Jairam's stories all over the shop keeps changing. Changed 2 or 3 times. Doesn't matter. The facts, the most he can say is that he saw her doing nothing. Doesn't matter. Because really it's all about what's happened before. Yeah, it's all what's happened before last year. That's the only thing that matters really. So it's just a pathetic fig leaf over another horrendous turn of the screw of this British injustice system. And there we have it. A bit of a ramble there, but I don't know where it's going to go now, and just hope that, I hope that reporting restrictions are now lifted, so that a number of people are going to be champing at the bit to start putting some articles out there, and hopefully a documentary or two in relation to how palpably obvious this is one of the worst miscarriages of justice in, well, certainly in my lifetime, and probably way before that even. I hope so. We'll see, won't we? We'll see. Bye. Thank you.